Hello, folks. Welcome to the busiest 60 minutes on television. In fact, on Enterprise TV, we call it Homo Politicus. You say it's number one, so let's go there. Emeka Anyaoku slams 1999 Constitution as amended. OK's 2014 Confab report. You know, one interminable debate in Nigeria today is if our problem is constitutional. The consensus in many quarters is that our problem is attitudinal, rather. Hear this. A former Secretary General of the Commonwealth, Chief Emeka Anyaoku, has posited that the 1999 Constitution, as amended, lacked the legitimacy of Nigerians. He spoke during a national dialogue in honor of the late pioneer Secretary General of Ohaneze Ndigbo, Ben Nwabueze. The dialogue attracted a cross-section of the political stakeholders in the country. And as far as Anyaoku is concerned, the 1999 Constitution has proved that it cannot address the country's current challenges. The elder statesman argues that the present Constitution is not suitable for a pluralistic society like ours, and that a new one is required. As it stands, we are all either a part of the problem or the solution. Let's have a conversation, please. My conversationalist today is Barrister Evans Ufeli. He's a constitutional attorney, and I welcome you, Barrister Ufeli.
Thank you. My pleasure.
Is our problem constitutional or attitudinal?
I think they are both. Our problems are both. Attitudinal in the sense that we have refused to change our approach to the way we do things. Even when the law have made provisions as to how we should undertake governance, live our lives and all that, we choose to go the other side.
I had a reason for asking the question, because the 1999 Constitution as amended, even though contentional, if we follow the letter and the spirit, as you people say in law, we won't be in a mess.
Yes, that's what I'm saying. I'm saying that largely attitudinal because we don't abide by the provisions of the Constitution, both from the government and from the citizens.
Yeah.
Okay, look at just yesterday, the Federal High Court refused to grant Nnamdi Kanu bail. Okay, but when you look at Section 35, 36 of the Constitution on the constitutional safeguards of citizens, whether suspects or not, he's entitled to bail.
Yeah,
but then they begin to bend.
Some offenses are not bailable.
No. Even murder is bailable.
Oh, murder is bailable?
Yes.
Treason is bailable?
Yes.
Okay.
It's a bailable offense.
But for the sake of some viewers who don't already know, can you name some of these unbailable offenses?
If you look at the law strictly, there's no offense that's not bailable, even homicide. But when they say bail is at the discretion of the court, it means that the court needs to be mindful of the suspect or the defendant is granting bail. If the court have the reservation that this defendant is likely going to jump bail, it is the prerogative of the court not to grant bail.
Okay.
That discretionary power given by the court is now being abused. That even when someone, deserves bail, is not granted bail. In the case I mentioned, someone was joined his bail, when the federal government went and invaded him and his family and killed people. And for self-preservation, they left. Now you are saying because of that is jump bail, because then you are not granting bail. The conditions should be looked at. That's just an example, by the way. That's not what we're discussing.
I know.
So I'm saying that, you see, we have laws that we have made provisions as to how matters should go and apply. Yes, but we don't apply that. So even if you have another fresh, brand new constitution, what is the likelihood there that we're not still going to, mess it up?
Yeah. So Emeka Anyaoku's position is debatable.
Yes, his position is debatable. You can say his position. You can say he's correct or right for saying that it lacks legitimacy because one, we the people of Nigeria, I mean, we did not converge anywhere. That is the opening of the constitution. We did not converge anywhere to come about what the structure of our laws should be, what should be constitutional, what should not be. All the provisions of the law from immunity to Section 308 down to the fundamental objectives to the fundamental rights, which is from Section 33 to 46, then Section 13 down to the rest part of it, talk about socio-economic rights. Then you go to the constitution proper, where you now have the first schedule. The second schedule talk about the areas where you have the legislative exclusive list and then the legislative concurrent list. The provisions there, the matters here and there, down to the residual, those issues. We're not talking about amending the laws. But you see, amending it will not change our condition. Yes, it won't change our condition because these same laws that we're saying...
We are likely not to follow the amendments.
We're likely not going to follow because these same laws... But it's good that we amend, okay, at least to show that we're moving forward. Let it not be that it's the application that we have problem with or compliance.
Yeah, because, Barrister, I'm tempted to ask if the 1979 Constitution applies here.
Yes, the 1979 Constitution is an offshoot. In fact, it was from the attempt to make Nigeria work and governable. Started in 1922. The first constitution in Nigeria, the Clifford Constitution of 1922, which created the elective principle from where we developed democracy. And natives were elected, Calabar and Lagos, in the House. We started from there. Then we moved from there to the Richard Constitution of 1946 that created regionalism and all that. From 46, we moved to the Litotin Constitution of 1950. Okay, Mark first in 1951, Litotin 1954.
Yeah.
Yes. These were all attempts before the constitutional conferences where we have before independence. Then we had Independence Constitution. Before the Republican Constitution 1966, 1963. Then you now have the Constitution that's in 1979 that took us back to democracy in 1979. Then from that 1979, you now have the 1999 Constitution. So if you look at the journey, not like the 1999 Constitution is a fresh written Constitution, it's an offshoot of 1979. Of course, for the 1979, there was, a coming together, a kind of. But in 1999, there was no such a thing. We didn't have any of those things. Then
But it was a rehash, as you said.
Yes, it was a rehash. Yes, it was a rehash. So, if you argue that it does not have legitimacy, one way you are right because the additions that were made to the 1979 Constitution, there was no widespread, like they are calling for memorandum now. Today they are calling for memorandum, for the Sixth Amendment of the Constitution. At that time, there was no such. We just woke up one morning and they said there's a 1999 Constitution. You understand? So anybody who argue that Constitution lacked legitimacy is correct. Okay? But that person should back up the statement with the fact that the lack of legitimacy, even if you have one that have legitimacy, like people are proposing the confab and all that. If you have the one that have legitimacy, it's not a guarantee that it will lead us to our destination.
But may I draw your attention to the 2014 confab?
Yes.
Was the 10th in the series.
10th, yes.
And so we have had 10 conference reports.
Yes.
We have done nothing with them.
We have done nothing with them because we're not serious about amending our constitution to, give us...
Amending or going for the spirit, what's spelled out in the Constitution and following through.
Following through the Constitution. You see, the conferences were all geared towards making alterations. Making alterations in the Constitution and all that. including asking for a secession clause in the constitution, which has never been allowed. Okay, so all these are attempts.
So
When you
not to
put
say
them
that
together,
the 2014 confab recommended allowance for any part of the country to secede.
it was raised, but it was vehemently shut down by the North. Northerners didn't allow that to even go anywhere. But it's part of the consideration. But you know, after all the memorandum and everything, they are still going to take it back to the National Assembly. And then the National Assembly will require the concurrence of the State House of Assembly. So for you to even pass it, even if it's agreed upon at the level of memorandum, it's not a guarantee that it will scale through at the level of lobby and the actual legislative.
When you go to seek the input of about 24 states.
Yes, put together as the legislative concurrence of the states.
Yeah,
it may not pass, but definitely there are a lot of aspects of the constitution that will pass for the fear of not putting the country at risk. So many persons actually turned against.
Yeah, and Ufeli, but I recall, as well as you do too, that the conference report was ready 11 months before the Jonathan government left stage.
Yes.
And nothing was done.
Yes, that is the irony of it. The government that funded the idea and did everything to make sure that we have that completed was unwilling to implement it. So, and Nigeria, you cannot truly say government is continuity here. You can't truly say so, because we have seen situations where a new administration would throw out at the back door everything that was laid down by the previous administration and want to do everything afresh. You understand? So there's no continuity here, because if the Jonathan government is unable to implement, which government do you expect to come and implement it?
So Buhari was right in washing his hands of it.
Yeah, the North also said that the selection.
No, is it the North or former President Buhari now?
I know I can't remember whether it's the North, but I know that there was a group.
The president said for the 2014 confab report, a no for me.
Yes, a no, because there were outcries that the selection for those who represented areas were uneven. And as such,
I recall that 200 came from the north.
Yes.
290 came from the south.
Yes, and they said it was uneven. And some people have gone as far as say that the outcome couldn't have been the collective wish of the people, given the disparity. So that one already has placed a legitimacy issue on even the yes.
Yeah.
And then the president not going that way at all, sealed it up. That was a no. Okay?
Yeah, sometimes aren't you troubled that my country, your country, appears not to know what it wants?
I am very, very troubled. Troubled because you see what ethnicity has done to us. Ethnicity and tribalism. Maybe because the country didn't work. And maybe because we have a very terrible history of both military takeover and a mix of military takeover and democratic rule, which has really punctured a lot of things. During the military, we were even more united. Yes, it didn't matter much where you came from under the military. You can aspire to whatever but under democracy, we bring religion, we bring ethnicity, we mix them, we harvest dirty solutions.
And these cynics would say that our forefathers sowed the seeds of discord. You tend to agree?
I don't agree. There were even those who said that the problem we have now started from the Litotin Constitution of 1954, wherein Nigerians were told they were not one, that the Constitution made. That was why we had the Willings Commission. The Willings Commission was supposed to obliterate
minority.
Yes. The Wahala we had then, the commission was supposed to water it down, because Um, through the attempt to come to a term with the right kind of model for governance for us, we did a lot of experimentations, and those experimentations at some point turned out to be contributed to the problem, because some of the laws heightened ethnic divide.
Yeah.
Some made an attempt to close up the gap. So at the end of the day, we're battling with both the law, ethnicity, and the people. Okay, we saw the Kano riot and even the riot in Lagos, where the owners of Lagos then had said some parts of the people from part of the country were taking all the jobs in Lagos. It created a problem. In Kano, there was a problem. So we've always had this very bitter experience as to one Nigeria living as one entity. So since we even if we go ahead to have a sixth amendment of the constitution, I don't see it even paving the way for.
All right. Might we talk about the flirtation, or so it seems, with the British type of democracy?
Yes, the British type of
The
democracy.
parliamentary system,
Yeah.
as opposed to the
The parliamentary system would have been the best for us at this time. Yes, it would have been the best for us at this time. But we don't have the kind of parliament that we want to suggest that, because that will reduce unicameralism. That will reduce bicameralism
Yeah.
to unicameralism.
Yeah.
And then the two houses will be fused, and you have just one entity. And the structure will now be a prime minister away from an executive president.
Yeah.
And then you are going to have
vested with so many powers.
yes,
so much power.
yes. But in this case, members of the parliament, members of both houses become members of one house, and they can have what they call collective responsibility. And decisions are taken faster here, because you only have a ceremonial president somewhere. You have a prime minister who is involved in day-to-day activities, and you don't need too much bureaucracy.
Are picked from amongst members of parliament.
Yes, there are people from among members of parliament, and you don't have the bureaucracy that you normally have when you want to take a decision, and you are moving from one part to the other.
Isn't it then surprising that the constitutional amendments don't talk about that?
The constitutional amendments
don't talk about a unicameral legislature.
They are those suggestions are made, but they are not taken. But what Chief Emeka is saying here, Anyaoku is saying here, he's not even talking about amendment of the 1999 Constitution. He's asking for a fresh constitution. Asking for, he said the 1999 Constitution.
He says, in the absence of a new constitution, the 2014 confab report should be adopted.
Yes, should be adopted. The confab report should be adopted.
But even the confab was skewed, had too many hiccups at the beginning, if you remember.
Yes, so many. There are a lot of interest.
The fear of domination.
Yes,
and so on.
Yes. The country and the regions did not agree to common grounds on so many issues as to how we want to live going forward. There were a lot of opposition as to some part of the country were of the view that Nigeria as currently constituted is okay. There should be no further restructuring. Some other persons in some other region of the country say no. You must create states and make it even. Let all parts of the country.
And you and I know that the present setup cannot create states easily.
It's not. All the states were created in Nigeria. Then none was created under democratic dispensation.
Yeah.
Not one, because
only the military could have done
only the military. So not one, because what the process, the amendment process that you
are
need.
we in a catch-22 situation?
Of course, we're in a rat race now. We're in a rat race because we suddenly discovered that Nigeria would have been better if we had a different kind of laws or different constitution. But we forget that our attitude is standing in between a good country and the one we have at hand.
Okay.
Our attitude is standing in between it. And it's our attitude that would ultimately define it, even when you have a new constitution.
All right. I think we apply the brakes here. But let me thank you for coming, Barrister Evans Ufeli. Many thanks for your time.
My pleasure.
So now you heard it, not necessarily from the horse's mouth, but from my discussant. He is a constitutional lawyer, so he knows what he told me. Um, so the debate will continue wherever you might be. Do we need a brand new constitution or change our attitude towards the 1999 constitution, however contentious it might be? I'm done. We should be here the next time. And until then, this is yours sincerely, Citizen Jones Hussein, thanking you for your time. Bye-bye now.